Hello, everyone. Welcome to This Week in Drones Tuesday edition. We're very excited to be joined by our friend of the podcast, Brandon Youngblood, who's going to go into depth on this new executive order from the Trump administration. Also, if you have any questions, we're going to be doing our call-in show on Thursday. So you'll be able to call in and ask specific questions about your situation, and our panel of experts, including Brandon, can really go into depth for your situation. So don't miss out and definitely call in on Thursday. We're also going to be at the Energy and Drone Robotics Conference next week. So if you want to book a meeting with our team and talk to us about your situations that you have or questions, definitely connect with us in person. We'll be happy to chat with you. And then, we're really looking forward to just getting some insight on this new topic and hopefully some clarity from Brandon. Brandon, take it away.
Yeah. Hey, thanks, David, everybody, for dialing in and walking through this with us. So first and foremost, this is outstanding progress. Finally, this is really the first directive documentation or policy, not legislation, but out of the executive branch office through the administration to highlight this issue and given the the sincerity and acknowledge the severity and what it is. So hats off to the administration and those who had input into this. You did some really great work. And, all of us out there in this space are very appreciative of it. So I did do just a kind of a summary, and Josh has got it on the left there, what I wrote up versus what the actual EO says on the right. And so we'll just kind of dive in through this section by section. The first section is really just highlighting the issue. Drones are being used for malicious and illicit reasons that can target, mass gatherings, critical infrastructure, military bases, et cetera. Drug cartels are using these to smuggle drugs over the border. Just really kind of encapsulating what that problem is. So not really too much to say there that we don't already really know. Section 2, just straight definitions, and again, all out of legislation, which is fantastic. So if you're wondering what unmanned aircraft system, why they haven't transitioned to uncrewed, because it's baked in law. And so that's why. So that's good that they have that there in the definitions. Policy is, again, just stating, hey, we need to do something, and it is the administration's policy to do something about it. So perfect. And then section 4, this is where we really starting to get into what I mean by directive. Like, you need to go do something, federal departments in the executive branch. And this is what me as the president am I telling you to go do. So one of these is to set up this federal task force to restore airspace sovereignty. So in my summary, it sounded a lot like the previous administration's National Security Council Interagency Policy Committee, IPC, for Counter UAS, and they formulated several recommendations for the departments to take. The difference between that task force or that IPC, NSC-led IPC from the previous administration, and then what this task force and what this administration is doing, and true to the nature of this administration, is just being, go do this. You are going to go do. We are not recommending you do something. We are telling you to go do something. And so I think that that's needed right now. There is no lead federal department for Counter UAS. And because of that, and the amount of equities that UAS security and Counter UAS cross, it's been a bit of a trouble as to, who can do what. So most of these departments, what happened is they kind of just went insular and just said, we're only going to control the area that we can control, which makes sense. But this, I think, will be different. The things that they're supposed to go look at, which again, the NSC IPC from 2021 did go look at as well, but it's relevant operational, technical, and regulatory frameworks that need to be changed in order to address this issue. So we'll see what comes out of that task force. Hopefully it'll be stood up very, very quickly and get going, and they'll have the right people in that room to address this that have the experience over the last 5+ years to answer what they need to answer.
Yeah, Brandon, do you have any idea? I mean, obviously you're not in the administration, so you don't know who they're picking, but do you have any guesses of anybody who they might tap for that, or speculation as far as that goes?
I mean, I can venture to guess certain offices. So DOJ, Office of Legal Policy, OLP. I don't want to drop names just for the sake of their own protection. DHS, COAS, PMO. They have a program management office. They'll probably pull some folks from CBP, FPS. A larger leadership core that's been inundated with this problem for quite some time. I'm sure NORA and NORTHCOM on the DoD side, and then the Office of Homeland Defense and Security. I don't know the full name. It's really long, but within the DoD. So I'm sure it'll be a makeup of a lot of the same offices that made up the IPC from many years ago. But a lot's learned since then. And this is a different administration. This is a different congressional makeup. There's a lot of differences where hopefully something a bit more aggressive will come out of it.
That makes sense.
So Section 5, airspace regulations to protect the public. So this is just, again, recalling, hey, 229 needs to come out. Let's get it out. Thankfully, the FAA did send that up to the administration for review. So I'm assuming the same office that was responsible for this EO is now reviewing the 2209 rule and making sure it's aligned with the administration's policies before they kick it out for comment and feedback per the rulemaking process. And the one thing that's really interesting in here, this is the first time I've ever seen any direction towards the sector risk management agencies. I personally do not know a lot about this, but from what I did research, it's embedded in DHS authority, which is Title VI. And what it is this is really a cyber infrastructure and security agency. So CISA directive saying this is how you conduct a risk management analysis or, risk for certain critical infrastructure and different other types of facilities that are important to, national security. So we'll see how that manifests inside of 2209 to, I guess what they're trying to do is make some kind of justification or criteria for being able to obtain a Section 2209, which is a drone only flight restriction, airspace restriction. So we'll see how that shakes out. I'm not 100% sure, but yeah. This next one, the subsection C, is kind of interesting. This is something that we played around with inside the FAA while I was there for quite a while, trying to make something work. But the notice to airmen, or the NOTAM system inside the FAA, is a text-based system. So it puts out, a text. Sometimes there's shape files that accompany with a temporary flight restriction, like a 99.7, a 91.141, or, whatever the other ones are, 137s. And the issue with some of these TFRs is they are text only. And so they do not integrate well with third-party airspace tools like the Before You Fly app when it was there, Aloft, and some of these others. And it's just a legacy dated type of system. And so the FAA does use the FAA UAS data delivery system, FAA UDS, to publish some type of airspace awareness knowledge that is exportable, that you can feed into a third-party software system to allow for what this thing is calling for is basically geofencing. But you can export that data, upload it into a software of a drone OEM system in the nav, and by GPS restrict the drone from being able to enter that airspace. Many of you know DJI had this enabled for their systems for a long time and have since removed that. The problem that we ran into are things like the stadium TFR, which is 99.7 flight restriction, airspace restriction that goes into effect 1 hour before a game and then 1 hour after the game. The problem with sporting events is that you can't really predict when a game is going to start and end. Typically, the start time is pretty secure, but there's weather delays, things happen, whatever. Baseball can go into the 12th inning of whatever. So it was very difficult to say, all right, now is the time to stop it. So what the FAA did is leveraging the NOTAM system and saying this law now exists. So you have to be aware as an operator if there is a major league game going on around you and you have to know when that game starts, and then you have to keep track of when it stops. And that's on you as an operator to understand and know, here's your warning through the NOTAM system. What this is really calling for is saying you need to automate that. You need to apply some type of shapefile so that can be ingested into these airspace awareness tools to allow for greater awareness by the operator. And that makes perfect sense. It was just not technically feasible for a long time. The only issue I see with this is that this is really calling for a new program and a new system to be developed, but it's unfunded because Congress controls appropriation. So Congress would have to go give money to the FAA. The FAA would have to go back and say, hey, I need the money to go build this thing based on this EO. We need money to do it. And so we'll see how that shakes out. Hopefully this will get funded through Congress to go build.
Do you think they might do some public-private partnerships where they just have a really, easy integration to, some of the systems you mentioned, and then you just have to be utilizing, one of the different available, commercially available apps, and then if you're not using them, then you just can't fly? Or do you think that that's not really a realistic way for them to move forward?
No, I don't think the FAA, and rightfully so, as an operator, I wouldn't want the FAA to mandate that I have to use one of these tools to go operate. That's against the structure of how airspace works in the United States. And you could even make an argument that would technically be illegal because it's blocking my public right and access to the airspace, especially if I'm like flying in Class G where it's just VFR. But I do think there can be a better job of airspace awareness to help operators know where they shouldn't or should be flying. NOTAMs it's an old system. It's probably 2 decades old in the way that we've been using it on the computer side. There was a program, it was called NOTAM modernization, to upgrade it, but nothing really kind of came out of that. And this is largely the same system that's been there for a long time. So I think this is a forcing function to upgrade the NOTAM system and make it more of a dynamic airspace awareness and, bring it into the digital age, if you will, to do that. All the technology exists. It's just a matter of funding the program to build it.
Yeah, it makes sense.
Let's see, section 6. Oh, this one I absolutely loved. And this is probably a contentious, tense, perspective. Many on the security side think it should be one way, and many on the safety side think it should be other. Anyways, I'm getting ahead of myself. So largely the FAA, and I think the timing was right over the last 20 years, was an educate first rather than enforce policy, saying, hey, if we go out there and we see a drone operator and we make contact with them and their drone's not registered, instead of applying, enforcement, saying, here's your fine or whatever that is, we will educate and release, right? So you need to go register your drone. Here's the website to go do that. Here are all the things that you need to go do. And for a long time, that made sense because the accessibility of drones at the cost basis that it's at, you can go buy them at Kohl's. And so a lot of these folks didn't understand, when you bought this thing, when you put it in the air, now you're part of a very highly regulated and a dangerous system. And it can cause some really dangerous situations if you're not operating within the regulatory and framework. I think today drones are so pervasive now, and especially over the last 2 to 3 years, the usage of them has been so amazingly highlighted, especially with the issue in New York and New Jersey that came up, the drone hysteria out there, the drone colliding with the super scooper in California for the wildfire. We need to stop or curtail back the soft touch of the educate first and enforce later. We need to start enforcing aggressively, in my opinion. And I know on the security side, many folks we need to start aggressively enforcing regulations rather than educating and releasing, because we're beyond that now. And I think that's what this is trying to state, is to leverage those laws on the books to start applying some pressure in the enforcement side of things. So that's that. I'm sure I ruffled some feathers on some folks, but that's okay. The rest, yeah, go ahead.
Oh, yeah, just talked about quite a bit, just in many of our episodes, just a lot of the detection piece. Would be interesting to kind of get your perspective on the Section 7 here.
Yeah, so this one's interesting. So it says so this one's steep in law. So when Congress was looking at drone detection capabilities within House Judiciary committees, what happened is they said, we think by executing a drone detection mission, which is the capture of electronic packets and the decoding of those packets, again, we think, we being judiciary, you're violating wiretap pen trap laws in federal criminal code. That federal criminal code is based off of the 1934 Communications Act, when Congress back then said electronic communications were protected by the Fourth Amendment, which is unlawful search and seizure. And so what this states, and I'm not really sure how this is going to go over, but it's basically the administration saying DOJ, DHS, all these others, they need to explore beyond, current usage into expanding drone detection equipment to SLTT and some of these others. But they've been down this road so many times. I don't know of any other legal way to look at this other than it actually going through the court system and litigation being filed and a judge making a ruling and possibly all the way up to the Supreme Court to say whether or not drone detection violates Fourth Amendment rights and federal criminal code would apply. So that kind of dovetails into this next one, which is the advisory on application of federal laws to acquisition, use of technology, blah, blah, blah. So what happened in 2020, because these laws were so kind of murky, the DOJ, DHS, FAA got together and put together this advisory. And Josh, you can pull that up. I think it's your second tab. This is the advisory that was put out in 2020, which kind of captures all of the potential laws that one may or may not be violating if they conduct a UAS detection or mitigation mission. Again, they can't say whether it would violate it or not because none of it's ever gone through litigation. So this is a theory. This is a legal theory that you'd be violating these laws. It is not proven. The only way to prove it is to go through the court system, litigation, and for a judge to make a ruling. So this, again, it's almost 5 years old now. And so they want DOJ and these other agencies to take a look at this again. However, none of those laws have changed. So I'm not sure what would change as far as this advisory. Maybe make it a little bit more into plain language so it's not so legalese and that only lawyers would maybe understand it. But this is out there for people to digest and kind of understand the legal framework that exists for UAS detection and mitigation. Yep. So subsection C here says within 60 days of the order, the FAA shall provide, again, extended permitted by law, an automated access to PII associated with UAS remote ID signals. So the catch to this, and again, I would have worded this a little bit differently, and I think the intent is solid. It is great. It's conversations we had inside the FAA plenty of times, but remote ID doesn't broadcast any PII data. So there's a kind of a loophole in here where somebody didn't want to have to comply with this subsection. They could just say, well, I'm giving you remote ID access, but there's no PII associated with it, so I don't really know what to do. What they could do, and this is what I recommended a long time ago, which was correlate the remote ID signals to the registration database and to the COA and waiver databases, so that if you pick up a remote ID signal, what happens is it automatically hits all those other databases inside of the FAA if you're a law enforcement agent, and you can pull all that data in real time. And so then you can see, hey, I'm tracking this drone. It's near Chicago O'Hare, but I see based on what I'm getting, it has a COA that's assigned to that based on a serial number, registration number, something that's associated with that remote ID. Again, unfunded program, it should exist. That takes effort, but all within the possibility of current technology. Probably 10 years ago that could have happened. So again, the intent here was perfect. I would have changed the language a little bit, and we'll see how they execute on it. What else we got? So then subsection D is just say, hey, DHS and the FAA should coordinate with the SRMAs to help critical infrastructure, private owners and operators in employing technologies that detect, track, and identify drones. Again, you're running into a little bit of a legal issue, gray area, where they don't know. With that said, there are plenty of detection equipment or technology that exists that would be very black and white as far as it doesn't violate wiretap, pen trap, radar, EOIR, acoustics, remote ID, capture technology. There's plenty of them out there. Drone Sense, Drone Spotter, some of those companies that produce. So Gargoyle Systems has one as well. And so I think that's what they want DHS and FAA to go do, is say, hey, you can go deploy all these systems.
Do you think that there'll be a requirement to start deploying systems like that, or do you think it's more of just a strong suggestion, or like what level of, I guess, force is there for people to start deploying these kind of systems, especially with critical infrastructure?
Yeah. So one of the recommendations that came out of the NSC group 3 years ago was to come up with this, or 4 years ago now, was to come up what they were calling the approved equipment list. You could modify the intent behind this AEL and say, these are all the technologies we can guarantee or for sure that DOJ says does not violate Title 18 wiretap pen trap laws, radar, EOIR. One of the things the government can't do is say, go look at Echodyne, go look at Robin Radar, they can't spell out specific companies because they can't do them all. And if they miss one, they could potentially be sued. But that's where I can come in, and you could come to me and I can give you a list of companies, because I don't represent the United States government or a governmental entity. I'm a private citizen with my own company. And that's where I think a lot of these technologies, and giving that unbiased analysis of what technologies you can integrate into your security systems and airspace awareness around your facility now, that's something that I could definitely help with. And there's a lot of others that are very brilliant in this area that can help with as well.
Yeah, it definitely seems like something that do you foresee in the future, like especially once a law is passed, that part of especially critical infrastructure sites could be required to start doing that, like they are required to do other security measures, or do you think that's still a little ways down the road?
I think it depends on how the regulatory oversight of whatever that critical infrastructure element is, right? So I can't speak to the oil and gas industry, how they're regulated, but maybe the nuclear energy producing area that's very highly regulated by NRC, DOE, and then NNSA, the National Nuclear Security Administration, might come out and say, hey, you need to have this now as part of being a nuclear power plant producing company. You have to have some type. I don't really know. That's something I could probably go find out by talking to some of the associations. There's a Nuclear Energy Institute, which is out there, that could advocate on behalf or not for that. I think many of these private industries would not want to be told that they have to go and invest in X, Y, or Z. I'm sure that some of those security requirements do exist based on federal oversight requirements, but maybe potentially, I'm not sure that anybody has the appetite to be that directive, at least not yet.
Yeah, no, that makes sense. And it seems like, there's probably still, this is just an executive order, but until it's really in law, it still doesn't have quite the same teeth that, it could have if, once Congress passes the bill. One thing I thought would be really fascinating, I know we don't have too much time, but what do you think this will kind of help steer a future bill from Congress? Or because I know we've talked quite a bit about how a lot of the bills just are not necessarily very effective, or the wrong language, or the wrong process. How do you think this is really kind of setting that conversation now on the right track? Or how do you think it's going?
Yeah, first, I don't think the current bills in place, there's anything wrong with them. I just think they're outdated. We've learned a lot since then. We need to refresh. There are some gaps that we need to cover, and we've learned those over the last 8 to 10 years. So that needs to go in there. So actually, it's great that you're bringing it up, and natural segue into the Section 8, which is enhancing general protections. So 6 USC 124 NK if you pop to that, that's the third tab on your screen there that I had you pull up. So embedded inside of 124N, 2661 for DOE and 130I, there's this definition section. And inside that definition section, you can see there's subsection 3. It says covered facility or asset. Now, this gets into the heart of what Congress is telling these federal departments what they can cover. And to the best way to explain that is like the Transportation Security Administration, or TSA, is not written into this law. And airports are not considered a covered facility or asset. So by congressional direction, there is no federal department that has the legal authority to protect an airport based on the way the law is written. And that's what I'm saying. It needs to be updated. So what the EO said, take a look at this definition section in 124N based on what a covered facility or asset is. And then what we need to do is we need to assess, is what they're saying, take a risk-based assessment and make a recommendation to Congress or the administration on if the northern and southern borders, large airports, federal facilities, writ large, critical infrastructure, other military installations, et cetera, need to be added into that definition section of a covered facility or asset. Many of the federal departments have been asking for this for years through various legal changes to their respective authoritative law. It just hasn't happened, right? And so I think this was the administration listening to all of those federal departments saying we need expanded coverage over certain facilities that are not in the law today. And that, I think, is what really will affect Congress in looking at these two. So I think that was awesome.
No, that makes a lot of sense.
And then there's just two more I'll cover real fast. So the building counter UAS capacity. So this is to basically take counter UAS and put it into Joint Terrorism Task Force, which have been around since, quite a while, since 9/11. There are working groups. There are joint counter UAS working groups. We call it the CWIG, which is one. The counter UAS, I can't remember what it's called. But anyways, so DHS, DOJ get together and they say, hey, here are all the SEER 1, 2, 3, 4 events, mass gathering events that are national events. Who has the resources to cover what? Does this one have a security need or justification to be covered? And so there's this working group that's held, I think, weekly within the federal government to say the Super Bowl is going to go be covered, and hey, FBI, they're going to go cover it, right? Or they'll volunteer to go cover it. World Series, the Indy 500, certain events like this, that's where that happens. So I think this is kind of putting it into a different bucket within the terrorism bucket, which is fine. But a lot of this stuff kind of, sort of, in a way, loosely exists in a more unofficial capacity. The other one that I think is fantastic is putting together in the creation of a national training center for counter UAS. I don't know if this will go to DHS or DOJ. DOJ has been advocating for this for a long time through the Drone Act, which was to place counter UAS national training inside of their explosive ordnance disposal school. So every EOD tech in the country goes through the same FBI school, and they are all trained in the exact same standard process for safely handling bombs, right? So that would place, again, a centralized place to, create standard language, standard practices. So no matter if an FBI agent went to Texas, California, Washington, Montana, as they're working with local law enforcement, they're all trained in the exact same way. They speak the same language in the purposes as it regards to counter UAS operations. And they want to set this up. Obviously, you got FIFA coming up in 2026, and then the 2028 Summer Olympics. This has to be in there before those happen to make sure that, we're all on the same page. And then Section 10 is just saying, hey, nothing in this shall impair a secretary's ability to execute based on their current authorities. So that was a lot to cover in 30 minutes, but hopefully it helped sort of parse through some of this and what they're trying to get at. It's great to see. I think it'll help the departments focus and move forward in a certain manner while Congress is shaking out the law.
That makes sense. Do you think that there's any kind of like, I know we don't have much time, but just like one thing that people can start doing now, like let's say you're, like you said, managing a nuclear facility or a power plant or an oil and gas site, and you're thinking ahead and you're like, hey, maybe right now there's not a specific law in the books, but it's probably coming down the pipeline to where there's gonna be a little more pressure on even just circumstance where your insurance is gonna want you to do something if nothing else.
Yeah.
Like what's people can do right now to start preparing themselves?
I mean, look, it's going to take one incident for the insurance fund. I mean, that's something that a lot of people don't talk about is what it takes to insure some of these facilities. And if you're an insurance person and you insure a facility and they're doing nothing to protect their site that you are insuring from drone incursions, which are an obvious threat, that might be a problem. So for those facilities that have vulnerabilities to drones, there's so much you can be doing right now. You can be creating procedures, you can be getting training both for your security staff and for your normal work staff. I mean, active shooter threats was a major problem and no one was trained on what to do if an active shooter happened. It took a lot of bloodshed for just the general staff to receive an annual active shooter training course. This is no different. If I pull up into, let's say I work at an oil refinery and I go into the parking lot and I get out of my car and I hear, and I see a drone over my head. Do I, as an employee, know what to do? Do I know who to call? Or do I just look at that and say, there's a drone over me? I walk in and tell all my friends about it. There was a drone over me. That's that type of understanding and procedures. And, this is the number you call if you see a drone that's over the facility, right? Your security personnel are going to want to know about that. I'm sure the corporate leadership is going to want to know about that. There's various infrastructure changes and security measure investments that can be made today. Perimeter security is no longer, we're going to stop everything at the property end line with a fence. Those days are gone. So you have to now look internally on what security infrastructure we need to put into place to protect certain things, right? What's the relationship with the local police department? Does the police department know what to do when you call them and say, hey, I have a drone overhead? Do they have remote ID detection? Do you have an airspace awareness system that you can pull up a bunch of data that's surrounding? There's plenty of companies out there now that have that type of software system that you can purchase and pull in others' data so that you don't even have to invest in your own drone detection systems. So there's tons of stuff that can be done today and that should be done today. And then when the law does change and you can go mitigate, and cool, you're already set up. Now you just integrate that new piece of technology into the program that you developed today. And that's what I think. And that's why I left the FAA, was to help these organizations develop these security programs and make sure that they do everything that they possibly can to secure their facilities now.
That's really important. And for anybody who's interested in getting this overview from Brandon, kind of getting his summary and also commentary, we'll have a link that you can click on and register on our site and then get emailed this overview. And if you have any questions, we're definitely available if you want to book a time to talk with us and just see kind of what your situation is and how we can help you out. We're definitely happy just to have a conversation. And, our goal is to make sure everybody's safe. So, we're definitely working towards that. I know the whole community is, but we're trying to do our part, keep America safe. And then I know we got a couple questions during the show. If you guys did have questions, or maybe there's a specific situation you're wondering about, or maybe a facility and you're kind of wondering how this might affect you guys, on Thursday we're gonna have a show with David and the rest of the panel, and Brandon will be there as well. And we would be more than happy to have you call in and ask your specific questions and really have an interesting conversation that's practical for folks so that they can start learning about this more. And then don't forget, we'll also be at that drone and robotics show, the energy drone and robotics show coming up next week. So definitely take advantage to connect with us in person there as well. All right. Thank you so much, Brendan. And I hope everybody has a great rest of your week, and see you Thursday.